What are some of the beliefs or biases that make a lot of jurors, initially at least pro defense?
Well, what we found was we used to call these untried issues because what we discovered is these things were very important to a potential jury, but not necessarily the lawyer. So they would try the case and they would never deal with these issues. And the issues were causing them oftentimes to win or lose, and they wouldn't know why. An issue like personal responsibility. Jurors were extremely, and still are, it hadn't changed, conscious of the responsibility of the plaintiff and the defendant. But when people say personal responsibility, they don't say corporate responsibility. They say personal responsibility. And so that was one of the things that we discovered and figured out how to deal with. Fundamental attribution error is that most people, when they look at a certain set of circumstances or a person, attribute responsibility to the person rather than the situation. And science shows that most normal people will react in a very similar way if they're under the same set of circumstances and situation. So if you've got in your case a fact pattern that you think they're going to blame the person rather than the situation, you need to use the framing and the other aspects to change it around so you deal more with the situation rather than allowing them to blame it on the person. Now, depending on which side you're on, if you're on the defense side, you would like it to blame the plaintiff. If you're on the plaintiff side, you want them to blame the defendant. So you frame your case and order your facts and presentation to do that.
What are some things people do, in putting together a trial story that backfire on them, that actually kind of play into the pre-existing pro-defense biases?
Well, one thing that I know I did, and most lawyers do, sometimes they have some really good facts and good information and they hold it. They either want to bring it up toward the end of the case to sort of shock a jury, and or they want to use it in rebuttal. And we found that from the availability principle, the opening statement's critical. You want the facts to be consistent, complete, and credible. And you want them to close that story, close it up on the story. So you don't want to save your best stuff later.
So what do we do to learn what our jurors' prior thinking is likely to be?
Well, there's a lot of ways to do that. It depends on what you can afford. We think concept focus groups is the gold standard. And there's various steps we would go through. First, concept to find out what their attitudes and beliefs are. And but if that's something you can't afford, and we all know, I mean, I practice in a small town. I've got cases I can't afford to even do my own focus groups on, but I don't. I'm not an advocate of doing your own focus group, because if you're like me, you get so attached to your client, you see what you want to see. You just can't be objective enough to do your own focus group. But focus group's one way. If you've got the money and can afford it, you do a series of those, you do surveys. If you can't, then you try out your case on your friends, your family, your relatives. You see an issue that's in the paper and you go online and see what all the comments are. You look at a newspaper article, you listen to radio, talk radio. You get all the information you can as to what the people in that venue think and believe about things. Try to learn that so you can present the case in a way that's palatable and acceptable to them. So empathy, not sympathy. Sympathy is what they drop in the tin cup as they walk past somebody who's maybe begging on the street. But empathy is when they put themselves or their family in that position in a way that helps you get them to analyze the case the way you want them to analyze it. you got a problem there with defensive attribution, which I explained to you earlier, that if this can happen to them through no fault of their own, it can happen to me. So they would say your client should do something else. But it's important to understand and not argue for sympathy, but empathy.
What are some things we can do to kind of create empathy with our jurors?
Well, one thing is maybe use some abstract arguments rather than as personal. What would so-and-so think or feel about such and such? Do it more abstract, or even to create it is if you describe what happened and how it happened and the hospitalization, you might say, you can just imagine what the family thought when they had to go in that hospital and walk down that long hall, knowing they were going to see their mother or their father. That creates empathy, but you don't do it personally because they'll react to it, but you put it in a third person. I wonder, you can imagine what they would have thought, how they would have considered it. It's easier for them to do that than deal with it personally. Think about framing. And framing is overall, and it can be minor. For example, if you ask an eyewitness, how far were you from the crash when you say you saw it? And they say 75 feet. Or you ask the question, how close were you from the crash when you say you saw it? And they say 75 feet. In the jury's mind, they will perceive them being closer if you use the term close, and further if you use the term far. So framing can be used in a myriad, multiple ways, not only in language, but in overall case frame, in the order of the presentation of the facts. Framing is a big part of the trial story, but if you put all this together in the story, and then you test it, and you modify it, and you shape it to get it consistent with their beliefs in the best way you can, you got the best chance of getting a fair result in that case.